courts, because of the importance of the constitutional issues involved, we granted the separate petitions for certiorari. We reversed the judgment. We hold the rule of law applied by the Alabama courts and the racist judge. They didn't say that. I'm saying that. Is constitutional.
Could you imagine? Oh my gosh.
Oh my God, I would love that. Supreme Court
Me too.
is constitutionally deficient for failure to provide the safeguards for freedom of speech and of the press that are required by the First and 14th Amendment.
The
Judge.
14th Amendment does matter.
Even in your courtroom.
In all courtrooms.
In a libel action brought by a public official against critics of his official conduct. We further hold that under the proper safeguards, the evidence presented in this case is constitutionally insufficient to support the judgment for respondent. So here's something in this case that the Supreme Court does that it almost never does. Okay,
Really?
It does something crazy in this case. Yeah.
Oh my gosh, I want to know so bad.
So how many times have I said, okay, the Supreme Court remanded it and sent it back to the lower court, right?
Yeah, all the time.
Every time. This time the court said, no. We don't trust the lower courts. We're not sending this back. Here's the judgment. The New York Times wins.
They're taking the whole thing on themselves.
They took it back and said, nope, we're not remanding this. This is how it goes.
I love the Supreme
yeah.
Court right now.
Isn't that so crazy?
Wow.
They never do.
So
I mean, they
crazy.
can and they do. When I say they never, obviously they do sometimes. But like so rare, right?
Yeah, that's not common.
As rare as it is for them to take a case from a state court, it is for them to like not send it back to the lower court to apply their new rule. That is the normal process.
Entire case is rare in itself.
I feel like after looking at all of this, they were pissed off partly at that judge for being like, the 14th Amendment doesn't apply here. And then the Alabama Supreme Court affirming every single point.
And it's like, no.
Mm-mm.
Good for them for taking control and saying, this is not happening. We get the final say.
Especially when it comes to the First Amendment.
Correct.
You know?
And this, you said, was like one of the First Amendment cases that needed to go up to the Supreme Court for them to make a decision on?
This is the one that laid out the rule for defamation for public officials.
Yeah. Okay.
So the court goes on to say, the second contention is that the constitutional guarantees of freedom of speech and of the press are inapplicable here, at least so far as the Times is concerned, because the allegedly libelous statements were published as part of a, quote, paid commercial advertisement. Instead, it communicated information, expressed opinion, recited grievances, protest claimed abuses, and sought financial support on behalf of a movement whose existence and objectives are matters of the highest public interest and concern. That the Times was paid for publishing the advertisement is as immaterial in this connection as is the fact that the newspaper and books are sold. Any other conclusion would discourage newspapers from carrying editorial advertisements of this type, and so might shut off an important outlet for the promulgation of information and ideas by persons who do not themselves have access to publishing facilities, who wish to exercise their freedom of speech even though they are not members of the press.
Yes,
right?
Absolutely. Love this.
The effect would be to shackle the First Amendment and its attempt to secure the widest possible dissemination of information from diverse and antagonistic sources. So, we hold that if the allegedly libelous statements would otherwise be constitutionally protected from the present judgment, they do not forfeit that protection because they were published in the form of a paid advertisement.
Yes.
Right? Yeah.
That's fantastic.
I agree. I like that.
I'm loving their vibe even more.
Okay. And then page 16. One more part.
This is great.
I agree. Yeah. This is just a little bit more from the opinion. We hold that the Constitution delimits a state's power to award damages for libel in actions brought by public officials against critics of their official conduct. Since this is such an action, the rule requiring proof of actual malice is applicable. Okay, so that is where they're saying you have to show actual malice. That is the
Okay.
law now.
That's because they're deciding this now.
Yep.
Well,
They're saying
in during this case,
yeah,
not
during
not
now.
present day, but
Yeah, during the
okay.
case. Yeah, that made sense. So yeah, so they're saying we hold today, aka in this order, we're making this a new law that everyone has to follow. That's what we hold today means.
Okay,
Like that means a
cool.
lot, you know. And then they say that the Constitution, so they're holding it based on the Constitution, the supreme law
Nice.
of the land, delimits a state's power, which means limits a state's power, to award damages for libel. So they mean to create laws that let you sue for libel for damages brought by a public official against critics of their official conduct. Okay.
Hmm.
So it's saying the Constitution is the limit of this, not your little state law.
Right.
And since this is such an action, that the rule requiring proof of actual malice is applicable. So yes, you have to use actual malice. That is the law.
And you have to prove that it was actual malice
Hmm.
beyond a reasonable
So
doubt.
it's on the person bringing the defamation case to prove actual malice. If you're a public official and it's about your public duties, like I said, this expands through other cases to more people. But in this case, that's what they held, right? And that is really the core of the First Amendment, really at its
Totally.
core.
And this law is still applicable
Yep.
today. Like this
If
specific one has
anything, it's
not been
expanded.
overturned.